Welcome to the Bringing the Human Back to Human Resources podcast. I'm Tracy Chernoff, and I've spent my entire professional career in HR. Each week, we'll explore the delicate balance between people and business with the aim to reconnect the two and create meaningful outcomes. Listen in as I share my own experiences, challenge the status quo, and chat with guests from various industries about our mission to bring the human back to human resources. Hi, everyone. Welcome back to the Bringing the Human Back to Human Resources podcast. Thank you so much for being here for another week. Don't forget to rate, review, and subscribe wherever you're catching this episode. And if you are watching on YouTube, give this video a thumbs up too, if you can, even though that's not possible on YouTube. Anyway, this week is, we're going to talk about something that I actually just learned about. For whatever reason, I wasn't seeing this in the news. I wasn't seeing this in like HR, publications. And when trying to think about what topic I was going to bring to the podcast this week, I was doing some searching for, really whatever's going on in the media. And of course, I should say in the news, not necessarily in the media. Of course, there are always topics around like DE&I and AI, automation, all that stuff. And we've talked about that, and I'm sure we'll continue to talk about that. However, this topic around the NCAA and college athletes. So the NCAA is essentially the national, not essentially, it is the national, I had to look it up really quickly, National Collegiate Athletics Association. So this is specifically in the United States, where student athletics are regulated among, it says about 1,100 schools across the US. Oh, and actually one in Canada. And it organizes athletic programs of colleges and helps over 500,000 college student athletes who compete annually in college sports. And this was founded actually in 1906 by Teddy Roosevelt, former president. I did not know that. Another thing I learned today. And so basically what I want to talk about is this recent ruling that some NCAA students and athletes could be considered employees. So let me read you a summary here. So recently, the NCAA has been grappling with the significant legal challenges regarding the employment status of college athletes. A pivotal moment occurred on July 11th when the U.S. Court of Appeals for the Third Circuit ruled that certain college athletes could qualify as employees under federal wage and hour laws. This ruling arose from the case Johnson v. NCAA, where athletes argued that their roles in generating substantial revenue for their schools constituted an employee-employer relationship. This is fascinating to me. We'll continue. Let me continue reading. The court's decision did not definitively grant employee status to all athletes, but rejected the NCAA's attempt to dismiss the case outright. Instead, the ruling emphasized the need for a test to determine when an athlete's participation in sports, quote, crosses the legal line into work. This test would consider factors such as the economic realities of the athlete's relationship with their school, including whether the services provided primarily benefit the school under its control. And that is from Inside Higher Ed, and I'll link that. There are a couple of sources here I'll link in the show notes. So it continues by saying this ruling could have far-reaching implications for the NCAA and the broader landscape of college athletics. If athletes are increasingly recognized as employees, it could lead to significant changes in how they're compensated and managed, potentially upending the long-standing model of amateurism in college sports. The case is now headed back to a lower court for further examination, where these issues will be more thoroughly explored. That's so interesting, isn't it? That essentially these college students could be in an employee-employer relationship. And actually, when you think about it, it kind of makes sense, because there are some schools where when you are an NCAA athlete, especially depending on the sport that you play, there is a significant financial gain for the school. And I could see, I mean, I guess part of my curiosity for this is like, how, I almost want to know like how this was kind of uncovered. Like, was this a student that said, hey, I should be getting compensated? Or was this kind of like a team of attorneys who realized that there was potentially an opportunity here? So I don't know. I might have to do a little bit more research to understand that. But it's just, it's very interesting. And then I also wonder, like, are there implications to this? Like, could the implications result in these students, or maybe some schools, like reducing the investment that they make in sports, because that would also have a significant impact on athletes, student athletes, because many students, rely on these sports for scholarships and other things. And then I also wonder, like, if they are receiving, let's say, a full ride scholarship, like, could that constitute payment for their performance and, like, service, quote unquote, in the sense that they're playing a sport and they're generating revenue for schools, but the school is compensating through the means of scholarships and other, like, other forms of payment, like if they're paying for, I mean, who knows, some students might have everything paid for, not just, tuition, but also room and board and things like that. So I don't know, that's interesting. It's interesting. I'm looking here because I did see, I just can't find it, but I did see, oh, here, maybe this is it. So it's a $2.7 billion settlement. And I believe I read something about what some students could earn. I think it said around like $135,000 for male athletes and $35,000 for female athletes. And this, of course, had to do with, probably, I would assume, like the popularity and revenue generation of male sports versus female sports. Let me see if I can find it, because I thought that was interesting. And of course, all of this, everything that I'm talking about here, has to do with the FLSA, the Fair Labor Standards Act. So I realize that this is very US based, this conversation, but it's really, really interesting. And if you recall, I think it was maybe last year at some point, I did an episode on the importance of classifying employees correctly. Now, obviously, we're seeing here at a very large public scale that there is a classification issue potentially. When I'm looking here, so the NCAA sought to appeal the refusal to dismiss the case. So this has been going on actually for a few years now. It looks like 2021 might have been the first instance of this kind of being presented to the courts. It does look like there was a statement recently put out. I'm reading on USA Today, so again, I'll link all of the sources in the show notes. It says the NCAA is expanding core guaranteed benefits for student athletes to include health insurance, scholarships, academic counseling, mental health support, and career preparation. The association is also advancing a proposal to allow schools to deliver far greater direct financial benefits to student athletes. And then it continues on saying, in modernizing college sports, student athlete leadership from all three divisions agree that college athletes should not be forced into an employment model which they expect will harm their experiences and needlessly cost countless student athletes opportunities in women's sports, Olympic sports, and sports at the HBCU and Division II and Division III levels. But why would this harm their experiences? I don't know. Is anyone else like picking up what they're putting down? I'm trying to, of course I can understand at the level here that, no one should be forced into an employment model, but how would that harm student athletes? Because if anything, if they did have the opportunity to be seen as employees of the NCAA / their school, then they would have access to better benefits. Like, this is, I don't know, I think about this in the sense of like unionization. Here, these student athletes are really basically represented by the NCAA, but they're also represented by their schools. And so I imagine that if there isn't this, I guess, like forward thinking from either the NCAA or from their schools, like these students actually could organize. They could unionize and they could say, okay, we want representation. Like, this is really fascinating to me because it's so, to me, it was so unexpected for me to see this. And it's such an uncharted territory. I think it's very fascinating that we're seeing this come up. It says here in February, a national labor relations board regional director ordered a union election for Dartmouth College men's basketball players. Okay, see, so I'm not totally off base with this. Writing that because Dartmouth has the right to control the work performed by the players, and because the players perform that work in exchange for compensation, they are school employees under the National Labor Relations Act, the NLRA. A month later, the Dartmouth players voted to unionize. How did anyone hear about this? How am I just learning about this? This is wild. That was literally 6 months ago. Wow. Very interesting. Anyway, I'll continue reading. So they voted to unionize, although the school's pursuing a full NLRB review of the case and could pursue the matter in court. In addition, the NLRB's LA office issued a complaint against the NCAA, the Pac-12 Conference, and the University of Southern California, alleging they have unlawfully misclassified college students as student athletes rather than employees. That case is pending with an administrative law judge. Okay, so the National Labor Review Board is pursuing this. I feel a little vindicated here because I was kind of just pulling together some of these thoughts because I had literally just read about this right before I pressed record, and we are in a time crunch today, so I did not have like a ton of time to really do like a bunch of research before like I normally would like to. So I'm reading this like as I'm talking to all of you, and I do feel a little validated that was my first thought. So like, good for us for having some good judgment, but that's really interesting. This is ripe for union opportunity. Like this is a really good example of when labor relations has potentially some oxygen in the room, right? Like you have these students who have been classified as student athletes for decades, and you have now this really lawsuit saying that they are actually not student athletes, but they are employees. And then you have the National Labor Reviews Board saying, well, actually, these students should be represented and they should organize. And here's how they can unionize. So that's really interesting about Dartmouth. I am probably going to have to dig into this. And actually, I'm thinking of how we could potentially bring on a guest that I've had on in the past to help talk through some of this. So I'm going to see what we can do. But this is really interesting. I think it wouldn't surprise me. We saw a lot of union activity over the last few years. It wouldn't surprise me if more students who are athletes, I'm not going to classify them as student athletes in the event that they are truly employees. I am not necessarily the expert to say whether they're employees or not. However, when you think about all of the things that they are doing, it's kind of like the same thing as, or the same, like, let me backtrack. This article continues on to say that from prior legal cases, there's this new test basically to determine whether there are minimum wage laws that apply to college athletes. And it said that the athletes may be employees under the FLSA. So that, kind of coming back to this. Yeah, so it says the NCAA said that even if those two are, there's a 7-factor legal test that could be used to determine whether they're employees. So when we think about classifying people, like I mentioned, I published this episode like a year or so ago around the importance of classification. If these college athletes are performing in a way that does show through this test that they are employees, then it does bring me back to this question of whether, like, do they need compensation directly? Obviously, with the FLSA, there are requirements around minimum wage. But then I wonder, like, could you look at the full ride scholarship and all of these other financial benefits that they're given? Would that legally be able to be broken down into essentially what the wage they would earn would be? Like, let's say someone is going to a private university and it's $100,000 a year, like, and expected and contracted to play their sport for 4 years. So that's a minimum of $400,000. And obviously we know that each year colleges tend to get more expensive. So let's say at minimum they're getting $400,000. Let's say they have a full ride scholarship in quote unquote wages through these other means. Like, is that something that could come out of this lawsuit? Is that legal? I don't know. Some states, for example, like New York and I believe California, if I'm remembering correctly, have, when you think about internships, have very, very litigious requirements around how you treat interns. Throughout my experience in HR, I've come to a profound realization. Certain tools can truly be a game changer. That's why I'm excited to talk about Cocoon, the leave management software that's making waves in the industry. I've heard wonderful things about how Cocoon not only simplifies the entire leave process, but also keeps administrative costs low. Their automation handles the most complex parts of leave, from compliance and claims to payroll, saving your team countless hours and headaches about leave. Clients and their finance teams rave about the cost savings they've seen by taking advantage of state and disability benefits for their employees. Plus, Cocoon integrates seamlessly with top HRIS systems like Workday and ADP, ensuring a smooth process from start to finish. Head to cocoon.com/HR and see the value for you and your employees. New customers who mention my podcast are eligible for a 50% implementation fee discount. Again, that's cocoon.com/HR, cocoon.com/HR. Now let's get back to the podcast. Very seldom can an intern be unpaid. And interns can only be unpaid if they meet a certain minimum of requirements based on their, like, what they're going to be doing in their internship and what the employer is going to be doing for them. In some cases, interns can receive college credit rather than receiving an income. And obviously it depends on all of these other factors. So that's a very high level. Like, if don't use that as fact, you have to really dig into your state's requirements. But that's a very high level overview, at least for New York, that it's very difficult to have an unpaid intern. So this is where I say, like, does it depend then on the state, in the sense that these college athletes could be seen as receiving payment through the means of scholarships and academic support and things like that? I don't know. I think if I were an attorney on the NCAA side, even though I'm not an attorney and I have not gone to law school, I would probably try and make that argument. If I were an attorney for the college athletes, I would say those are just benefits to the job. Just like how in our jobs, if you work full time, you get health benefits, you get access to, other perks, maybe some wellness benefits and things like that on top of your salary. And some people get bonuses. So I could see this kind of going really either way. And then I would also wonder, like, do these students get access to health benefits if they are then seen as employees? How do the schools figure that out? And then when we think about those implications, which I kind of started this episode off with, what will the future of sports look like at these schools and within the NCAA? Obviously, they make tons of money for these schools, these athletes. And we've seen with the Olympics that many of the athletes that go to the Olympics have NCAA presence and compete within the NCAA because of the school that they're in. They're in potentially D1 schools. Like, all of these things do generate income for the athlete sometimes. Like, when we see someone win a gold or really any medal at the Olympics, they do receive some, sometimes they get like sponsorships, obviously, and they get income in other places. But the schools and probably the NCAA definitely benefit financially from these college athletes. So I just wonder then, like anything, when costs go up, is there then a cutting of costs somewhere from the schools? Or do they generate enough where they can actually reasonably pay these college athletes and continue to keep these programs going and thriving? I don't know. I don't like to be cynical about those things, but I do think sometimes we see, even if positive like this, if this lawsuit does then result in these college athletes receiving an income that's positive for them. But is there ever a negative, is there a negative consequence down the line because of something that benefits these athletes today? Like, does that shake out to be less beneficial in the long run? Not to say that it's right or wrong to pursue this. Obviously, if they're employees, they need to be paid and they need to be treated like employees. But sometimes it makes me wonder how much good is good enough, and like how if there is like this deeper consequence long term for athletes that do rely on scholarships, that in order to go to college, that do rely on these opportunities, like what that would be like for them. I don't know. I guess we'll have to wait and see how this shakes out, but I think this is fascinating, and it's definitely something that we'll have to kind of keep an eye on. And I do want to see if I can find out the amounts that, yes, okay, here we go. Hold on. So I mentioned earlier the potential payments, or like the amounts that these athletes would receive. So I mentioned like 135,000 for men and 35,000 for women. It's actually a little bit more specific than that. So let me just kind of add an addendum to what I said before. So football and men's basketball players would receive $135,000 each, roughly. And the average recovery for a women's basketball player would be approximately $35,000. Now it seems, I don't know, it seems that is the average payout from the settlement. I don't believe that is what they would receive as payment, because that wouldn't be minimum wage. So it sounds like that's the recovery from the settlement. And actually, this reporter, I'll make sure that this article is linked as well, from Bloomberg Law, this does highlight a gender disparity. And she continues on by saying that, it really highlights the gender disparity, because we see the men's basketball players and football players receiving this recovery of approximately $135,000, with the women's basketball players receiving approximately $35,000. But as much as I agree, I also think that context is really important. And the reality is that unfortunately, men's sports do generate more income and revenue for really whatever team they're on, whether that's college or otherwise. And it's an unfortunate reality, because women's sports are just as important, but that's kind of just the reality of the situation. I obviously don't know exact numbers, but I know that is just kind of what happens. And also, I think it's very easy for us to like look at these numbers and say, whoa, men are going to receive so much more from this recovery versus women. But I do think the context is really important. And I also think that just like in any business, it doesn't seem that it's necessarily based on gender as much as it is based on the sport that's being played. Football is very well known to be A, very expensive for schools and for teams, and B, very, very, very revenue driving. So that doesn't surprise me. And men's basketball, there's the NCAA like tournaments are massive in the United States. Unfortunately, the women's NCAA tournaments are not as widely followed. So I do think, like, when we think about this in the business context, not saying there isn't a disparity, but when we think about this in the business context, we do have to put it into the bigger picture and gain additional perspective on this. Because if you're in a business and you have person A generating $1 million a year and person B generating $300,000 a year, these are arbitrary numbers, person A is going to earn more. Or, obviously in the recovery of a settlement here from the lawsuit, they're basically looking to understand what is owed for essentially what feels like prior employee-employer relationship moments where they were not receiving an income and they were not receiving pay. So it's basically like back pay. That's what it sounds like. But the article doesn't really explain where that is coming from. So that's what I'm assuming this is relative to. So, I think, again, it's easy for us to look at these numbers and say, this is for men and that's for women. But we do have to put things into perspective and potentially hit pause and understand where those decisions are being made. And unfortunately, I can't find any more information right now. But if I do, of course, I will link everything in the show notes so you can continue to read it as well. But I just thought that was very, very interesting and a very interesting topic for us this week. And I hope that we can kind of continue to see how this shakes out and maybe even talk about this further with an expert, i.e. an attorney who can really help us break this down. So with that, thank you so much for tuning in this week. Don't forget to rate, review, and subscribe, and follow me on Instagram at hrtracy, and go to my website, hrtracy.com. Make sure you're signed up for my newsletter, which comes out every week at minimum, or I should say once a week at minimum. And I look forward to speaking more about this topic and hearing from all of you on your thoughts around this topic. Let me know, send me DMs, emails, respond in the Spotify poll, and we will chat soon. Thank you so much. Take care. Bye. Hey, just before you go, don't forget to subscribe to the show so that you are the first to hear when an episode drops each week. And maybe leave a 5-star review and a comment about how much you loved this episode. Plus, if you have someone in mind who would really enjoy this episode, make sure you share it with them. Thank you so much for tuning in, and I will see you next week.